Yes, we can begin.
Okay, I'll call the Tennessee Collection Service Board meeting of July 9th, 2014 to order. Ms. Whaley, if you'll read the roll call, please.
Yes, sir. Bart Howard,
Here.
Elizabeth Trinkler.
Here.
She's participating via teleconference. Elizabeth Dixon,
Here.
Steve Harb, Chip Hellman. Mr. Harb and Mr. Hellman are absent. Chairman, you have a quorum.
Thank you. Ms. Whaley, if you'll read the notice of meeting, please, for the record.
This meeting's date, time, and location have been noticed on the Tennessee Collection Service Board's website, included as part of this year's meeting calendar since August 16th, 2013. Additionally, the agenda for this month's meeting has been posted on the Tennessee Collection Service Board website since July 2nd, 2014. This meeting was also noticed on tn.gov's public meeting calendar.
Thank you.
Sir, you have your agenda.
Yes, ma'am. And will we review the agenda and adopt it as amended?
Yes, sir.
Okay.
With a statement of necessity for the teleconference.
Yes. And we have to have the teleconference and a roll call vote, please.
Yes, Mr. Chairman, that's correct. I'm going to read a very brief determination of necessity into the record, and then I will need a roll call vote to approve that. This is a determination of necessity for the July 9th, 2014 meeting of the Tennessee Collection Service Board. TCA 8-44-108 requires that a governing body which conducts a meeting electronically and without a physical quorum present at the location of the meeting make a determination of necessity as defined by TCA 8-44-108 subsection A3 regarding the meeting, that such determination and the facts and circumstances upon which it was based must be included in the minutes of the meeting, and that the governing body must file the determination of necessity with the Office of the Secretary of State no later than 2 working days after the meeting. The operation of the Tennessee Collection Service Board is governed by the Tennessee Collection Service Act, located at TCA 62-20-101 and subsequent sections. The board determined that there is a necessity for this meeting to be conducted with the electronic participation of one board member, and the facts and circumstances supporting the necessity of participation in the meeting of one board member electronically are as follows. Necessity exists for this meeting to be held partially electronically because the members of the board participating in this meeting are spread geographically throughout the state of Tennessee, and one or more of the participating board members are unable to be physically present for this board meeting due to other pre-existing and/or professional obligations. The board has authority to conduct meetings under the Tennessee Collection Service Act under TCA 62-20-104 subsection C, and the board hereby finds that it is a necessity to conduct this meeting in part electronically with the participation of one board member by phone in order to conduct and transact the ongoing business of the board as authorized by the Tennessee Collection Service Act and to protect the interest and welfare of the public. Mr. Chairman, at this time I will need a motion to approve and a roll call vote in favor of adopting this determination of necessity.
Move that we adopt the determination of necessity.
Okay. And is there a
pertaining to this
second?
meeting.
I second.
Motion's been made and seconded. All in favor, say aye. Aye.
We'll have to do a roll call vote for every
Oh,
vote.
I'm sorry.
For this meeting.
We'll have a
Bart.
roll call vote for the vote on the necessity for the
Statement of necessity.
statement of necessity.
Yes, sir. Bart Howard,
Aye.
Elizabeth Trinkler,
Aye.
Elizabeth Dixon, Steve Harb is absent, and Chip Hellman is absent. The vote passes, sir.
And minutes of the May 14th, 2014 meeting. I'm sorry?
We'll need to adopt the agenda as amended.
I'm sorry.
That's okay.
Is there a motion that we accept the agenda as amended?
So moved.
Is there a second? And I move second. And a vote on the motion. All in favor say aye.
No,
Aye.
I'm sorry. sir.
sorry, another
roll
roll call
call.
vote.
It's okay. Bart Howard,
Aye.
Elizabeth Trinkler,
Aye.
Elizabeth Dixon, Mr. Harb, Mr. Hellman are absent.
Okay. Now we go to the minutes.
Yes, sir.
We've had an opportunity to review the minutes via the email that we got after the meeting in May 14th. Are there any corrections or additions to the minutes of our May 14th meeting? Hearing none, I will accept a motion that we approve those minutes.
So moved.
Motion's moved. Is there a second?
Second.
And seconded. Roll call vote, please.
Bart Howard,
Aye.
Elizabeth Trinkler,
Aye.
Elizabeth Dixon,
Aye.
Mr. Harb, and Mr. Hellman are absent. The motion carries, sir.
Legal report, Mr. Whitaker.
You have before you in
Tab 2.
tab 2 the legal report. There are 13 items on the report for the board's consideration, and this time I will turn the report over to you, Mr. Chairman, and the other board members for review of the items, and please take notes for any questions you may have. And then once all of the members have read the report, I'll be happy to entertain any questions about the report.
I'm still waiting for that email to,
Okay. I'll resend it from a second device in hopes.
Elizabeth, have you had an opportunity to review the legal report yet?
I'm reading it right now,
Okay.
Bart.
All right.
I was a little late getting it, but I'm almost through.
I understand. Okay, just let us know when you're done.
Okay. Okay, I'm done.
Are there any questions about the legal report?
I have a question.
Okay.
Under number 2, case number 201-400-5201, was the reduction because there was no FDCPA violation involved, and that's why you felt it was?
Yes, Ms. Dixon, that's correct. The previously authorized $1,500 civil penalty was based in part on the FDCPA violation, so thought it appropriate to bring it back to the board and take out the part that was based on that alleged violation and leave in place the remaining amount that was part of the violation that, in my opinion, could probably be confirmed at a formal hearing. And, it's $1,000 seems appropriate for a first offense with the cease and desist provision, and hopefully this would have the deterrent effect that other similar orders would have to either, have these folks pay the consent order and then come get licensed, or pay it and then operate unlicensed in places where that's allowed.
Under number 11, I don't think there's anything in our statutes that prohibit an agency from buying another agency, but wouldn't it generally require that those clients going from one agency to the new agency have some sort of agreement to that transaction?
I'm not sure, Mr. Howard. I don't think the Collection Service Act necessarily says that, but it would certainly be a good idea from a business perspective, because if you're going to acquire the business as an ongoing concern, and that includes the clients of that business, they would presumably have to be comfortable with the arrangement, or they could just stop being clients. Because just from a general common sense sort of perspective, I would just about guarantee that the contract between the clients that were in place with the agency that was acquired by the other agency, their contract was not with the purchaser. Their contract was with the agency that's getting bought out. So, again, presumably there would have to be some arrangements in place between the purchasing entity and those clients of the purchased entity, but typically the board doesn't dig into or inquire about such things unless one of the clients of the purchased entity somehow complains of misconduct by the purchasing entity. And so far, we have not received any such complaints or issues in that regard. So it seemed like the next logical step would be to tell the purchased entity or the purchasing entity that if you folks want to continue to do business at this location, then because the ownership is new and the Collection Service Act says that licenses are not transferable, if you're going to do it under your existing entity name, you need a branch license. If you're going to do it under a different corporate or LLC name, then you will need a new application altogether. And so I feel fairly certain, having dealt with this purchasing entity before, that they will contact me as soon as they receive my letter and tell me which one it is they wish to do and go forward.
Thank you. Are there any other questions about the legal report? If not, I'll entertain a motion that we accept the legal report as prepared.
Move to accept the legal report as presented.
I'll second.
I move is to accept the legal report has been moved and seconded. On a roll call vote, Ms. Whaley?
Bart Howard,
Aye.
Elizabeth Trinkler,
Aye.
Elizabeth Dixon, Mr. Hart and Mr. Hellman are absent. Motion carries, sir.
Thank you, ma'am. Administrative report under complaint comparison report, tab 3.
Yes, sir. Ms. Trinkler,
Yes.
real quick, have you received the email? I've sent it 2 different places, so hopefully it came through.
Yes, no, I've got it.
Oh,
Actually,
wonderful.
I was just thinking I'm having an easier time with it on my on this than I do when I'm there. I've got it up.
Okay, wonderful. I just wanted to make sure before we moved forward. On tab 3, you have your complaint comparison report. Happy to report that the group is exceeding the divisional performance measure. Our current performance measure is 94.66% of our complaints being closed or referred for legal action within 180 days of receipt.
Excellent. Very good.
There are no questions about tab 3. Tab 4 is your monthly budget report. The first tab shows the revenues through the end of May, and your expenses through the end of May are on the following page.
Have that okay, Elizabeth?
Yeah, I got it.
Are there any questions about that? Okay. If not, we'll move to tab 5 through 7.
I'm going to let Mr.
Tab 5.
Yes, ma'am. I'm going to let Mr. Whitaker present tab 5 for you.
Thank you, Ms. Whaley. Mr. Chairman, members of the board, on tab 5, we have information regarding a license renewal application for Accretive Health, Inc., license number 1073. We have with us today in the audience Ms. Maria Hurd, who is counsel for Accretive Health, and then a gentleman named Thomas Merritt from, I believe, St. Thomas Hospital, a client of Accretive Health. And we have a somewhat of a unique situation that I've not seen before, but one that appears like it could be resolvable. Accretive Health is an entity which provides receivables and other services for mainly healthcare, hospital systems, organizations, what have you. And they do have a Tennessee Collection Service license that was scheduled to, and in fact did expire on June the 3rd, 2014. And however, their renewal application was timely submitted, and during the review of that application, it was determined that Accretive Health at this time may be unable to fully comply with the portion of the Tennessee Collection Service Act relative to renewal of licenses. This is under TCA 62-20-112, subsection B3. And stating that one of the requirements for renewal of a license is a current balance sheet prepared by a licensed public accountant or certified public accountant. The issue that we have before us is that Accretive Health has additional reporting obligations beyond those simply that they have to do for the Collection Service Board. Among the entities to whom Accretive must report is the Federal Securities and Exchange Commission. And after speaking with Ms. Hurd, she was kind enough to explain to me that in conjunction and working with the SEC, Accretive's board of directors and management team and their the accounting firm that is doing their financials have come to, I guess, what amounts to an informal agreement to restate certain of the financial information from not only the current set of financials, but also possibly going back some period of time before that. It appears that these restatements are related not to any allegations of misconduct or financial wrongdoing, but instead just some issues about when certain categories of revenue should have been booked. And so, as I understand it, Accretive is in the process of doing those restatements at this time, and Ms. Hurd and Mr. Merritt have provided some information that is more, I don't want to call it informal, but it's the kind of financial information the board would typically be looking for if it were certified by a licensed PA or CPA. However, it is at this time the company's internal financial information only, because it cannot be certified by a CPA and submitted until the restatement process with the SEC is complete. So I've also received written assurances from Ms. Hurd on behalf of her client that within 5 business days of the completion of the restatement process, the CPA firm or CPA certified financial statement that's required by the section of the Act that I mentioned will be provided to the board at that time. And so that's the summary of the situation. If the board has any questions, be happy to entertain them at this time. And if there are any specific questions to be directed to Ms. Hurd, she is available to answer them. Please speak into the microphone.
I'm sorry. Ms. Hurd, would you like to approach the podium? Your firm does collection work for St. Thomas Hospital, is that right?
What Accretive Health does for the hospital is manage the entire revenue cycle. So they do a lot more than just collect accounts receivable. Their work starts at registration when a patient goes in to register. So they work on the registration process, they work on insurance submissions, they work on getting uninsured patients charitable help to pay their bills, and then yes, they also do accounts receivable collections.
When you do accounts receivable collections, do you do it in the name of Accretive Health, or do you do it in the name of the hospital? Do you send out bills as we would call an early out processing program, or do you do it in the name of your company?
I'm going to have to ask Mr. Merritt to join in and help me with that. To correct the record, Mr. Merritt, he is here local in Nashville. He is an employee of Accretive Health, and what he is the site lead at St. Thomas Hospital, so he serves the client of St. Thomas to handle this work.
Okay, I think I've got this. So to answer your question specifically, yes, there is a portion of what we're doing in the collection realm that would be third party, that we would be making, sending letters as well as outbound phone calls that would be as Accretive Health on behalf of St. Thomas Health. So we do identify ourselves as third party.
And the monies you receive in that process are sent to Accretive Health for the client?
Actually, that's a good question. None of the funds that we receive from any patient interaction actually go through any holding account or any account owned by Accretive Health. 100% of funds are sent to either funds that are mailed or taken over the phone or going into a St. Thomas Health deposit box, whether it be their safety deposit box, their physical location, or an electronic deposit that's actually going to the St. Thomas bank account. And that's for the protection of St. Thomas, it's for the protection of Accretive Health as well. And so 100% of those payments will go through a St. Thomas owned financial entity.
Does your firm do this for other hospitals and other entities? And is that the business plan for your whole company?
Yes, sir. So we're in practice in a number of other states with other large facilities such as St. Thomas Health, mostly faith-based facilities like St. Thomas Health is, and that's the practice across our entire business, regardless of where we are taking that money, whether it's at the point of registration or it's the point of this early out process. That's how we do it across all of our clients, not just St. Thomas Health.
I have a question. Do issues arise in that process where the consumer is confused as to who is making the collections? Whether it's, in other words, if you call me and you say I'm Accretive Health and I say, well, good for you, you say you have a bill that's outstanding at St. Francis, and what am I, what am I to, as a consumer to, what
Yes.
is my recourse? Do I believe you or not, and how do you handle that?
Yes, ma'am. So we do introduce ourselves on all outbound and inbound calls. We answer these phone calls as this is Medical Financial Solutions, which is a DBA of Accretive Health, on behalf of St. Thomas Health. So we make sure that we are making our patients aware that we are not only a third party, but we are working on behalf of St. Thomas Health. The statements that they do receive reference St. Thomas Health as well. They do have the Accretive Health and Medical Financial Solutions logo on them, but we have come across that confusion, and we've dealt with it in a number of ways. Not only does the patient have the opportunity to dispute the debt, they might not believe that this is actually a St. Thomas Health debt, and so we have a very close working relationship with the folks on the ground at St. Thomas Health. In case anything is escalated past, I just do not believe that you are working on behalf of St. Thomas Health. We have a number of individuals, not only from customer service, but leadership within St. Thomas Health that have had to make phone calls or write letters, and so I can't say that it's never happened, but it doesn't happen all that often because we've been working on behalf of St. Thomas Health for 8 years now, and so the patients here in Middle Tennessee are used to getting those letters and those phone calls, especially the repeat patients that we've got.
There's a level of understanding there that you have that people may think that.
Yes, ma'am.
Okay.
Yes, ma'am.
Where is your call center? Is it here in Nashville or is it in Michigan?
It's located in Kalamazoo, Michigan.
Okay.
So we have our inbound and outbound capabilities through Michigan. It's been located there for roughly 5 years, and we've done that work for St. Thomas out of that facility.
Do you maintain a client trust account? I think our statutes require that you do that, but if you're not taking any money, I'm not sure why that would be.
Mr. Chairman, we have a piece of the application, both at initial application for licensure and renewal, basically says, if you have a trust account, please provide the information. If you don't, so state, and please attach an explanation. And so in my conversations with Ms. Hurd and the documentation that's been submitted, it's made pretty clear up front, as it was reiterated just now, that there's no need for Accretive Health to have a trust account because they do not accept or take or even hold St. Thomas or other client funds at any time. So that several years ago, as I understand it, that was somewhat of an issue where we had that question come up about, well, do we have to have a trust account if there's going to be $0 in it and we're never going to use it? And so that seemed like a fair and reasonable solution to not put licensees and folks who are trying to do business and create jobs in the state of Tennessee through unnecessary bank and financial expense for an account that would never be used. And so given Accretive Health situation, they would fall into the latter of those two categories.
Accretive Health is traded on the public stock exchange, is that correct?
It is a public company. It is not currently being traded because of the restatement process. And I'm not a CPA and not an SEC lawyer, but as their lawyer and coming here today, I learned about the process. And the way I understand it, and I needed it to be simplified for me, was that Accretive internally with its accountants looked at the way that it was booking its revenue and the timing of that. And there are differing opinions in the accounting world as to the proper timing of doing that. They had certain advice for the past and now have changed their mind and said, okay, this is the way we need to do it now. We have to fix the records going back retroactively. Therefore, we're going to work with our accountants. It was an internal determination. As Mr. Whitaker said, it was not because the SEC was investigating or there was any allegation of wrongdoing, but we now need to go back, and it's a very laborious process. They have to go contract by contract with each client and figure out how to properly apply the accounting principles and categorize all of that money. So that is why at the moment, and because of SEC rules, the company definitely wants to provide the board with the information that the board needs to show that the company's financially sound. However, we can't run afoul of SEC rules about public disclosure of information that we have now determined was incorrectly stated. So while we go through that process, what Mr. Whitaker has very kindly worked through with me is what information can we provide that shows that financial stability. One is what you very astutely were asking about is there a client trust account that if you have a financially unstable company, may they feel like they need to dip into our client funds at risk? And here we don't have that. Factually, you just don't have that. Secondly, the restatement process does not affect the cash flow of Accretive Health. So you still have that necessary healthy cash flow while the accountants are working on where do we put the numbers on the balance sheet.
Your accountants came up with the idea that you need to go back and restate your.
Right. It was a combination with the accountants and the internal audit board of Accretive Health. And attached to the renewal application, if you would like to do extra reading, there is a Form 12B-25 that Accretive submitted to the SEC, which gives a deeper explanation of the restatement process and why it's being done.
Do you have an idea when you will be able to present your financial statement?
Yeah, that also is covered by that filing. What I can say is obviously Accretive Health wants it done as soon as practicable, but it is a very difficult process. I am prevented from saying more than that to give a certainty on timing. Again, because of SEC rules, it's just not publicly available information.
But you will provide Mr. Whitaker with that statement, with that financial statement as soon as it's available.
Absolutely. What the written assurance that was provided is that within 5 business days of providing those restated financial statements to the SEC, we will provide them to the board through Mr. Whitaker.
Elizabeth, do you have any questions?
No, that was going to actually be my question, Bart, was about the timing on it, because I've just been trying to think if there's some way that we can give a temporary issuance, dependent upon receiving that or something like that. Maybe Chris can advise us.
Well, part of the reason that Ms. Hurd elected to come today is because the Collection Service Act is fairly unique in that it has a very stringent, not very flexible 60-day late renewal provision, and after 60 days from the expiration, on day 61, a new license is required if there is not a fully completed and accepted renewal application in the door with the board by that date. So the approximate date we're looking at is around the first week of August here, and obviously the board would not meet again before that August date. Given the written assurances of counsel and the financial information that has been provided, I think it's an acceptable exercise of board discretion to accept the renewal and to go ahead and process it and allow the license to be reissued so that there's no interruption of business or anything else with St. Thomas or other clients. And then if there are issues down the road with the financials as promised not being provided as required, then that could always be the subject of a disciplinary complaint if it came to that. I highly doubt that would be the case, but anything is possible. But that would be the remedy if it came to it. But given the amount of money at stake and also the attentive participation of the licensee and their counsel in this matter, I think the chances of that are very slim. And as such, if the board's asking for a recommendation, I would respectfully recommend that the board allow the renewal of this license to go forward on the terms discussed today.
If there's no other questions, I'll entertain a motion that we allow the renewal of the applicant based on the terms that we've received and the explanation from
I move to approve.
I'll second.
motion's been made and moved to approve. We'll have a roll call vote, Ms. Whaley.
Art Howard,
Aye.
Elizabeth Trinkler,
Aye.
Elizabeth Dixon. Mr. Harb and Mr. Hellman are absent. Motion carries, sir.
Ma'am, thank you all very much.
Thank you very much, members of the board, and thank you, Mr. Whitaker, Ms. Whaley.
Thank you.
Tab 6.
Yes, sir. Tab 6 is a new application for licensure. And the company has stated that they cannot accurately create a proposed budget at this time. A note from the company CEO related to the matter is located on page 8 on the iPad. This again goes back to the statute is very specific about what is required for licensure.
I remember this when I applied for my license in 1980, and it was tough. What are you going to do? How can you manage? And does this company now, are they in business now, or are they just going to start their business?
No, sir. As they state in the letter, we're trying to do everything correct, and we want to get our license before we go after clients in any states. So it is that. And that was a direct quote from the
I read that. Thank you.
And,
With great trepidation.
And Mr. Chairman, to your point, it appears that with tab 6, we did eventually get a very bare bones, rough proposed Tennessee budget. And basically, on the cost side of the ledger, it's the expenses to apply for licenses from this board and the ACA, plus getting a registered agent for service and other purposes. And then on the revenue side, it's basically contingent income. They do believe they have a client that would make use of their services, but they're not going to be offering those services or conducting any collection business until and unless the board grants them a license. I think it's a little obviously more basic and rudimentary than we sometimes see, but I also think it is a good faith attempt to comply with the statutory requirements based on the obviously limited financial scope and wherewithal of what appears to be a small company. So with that, the late received proposed Tennessee budget, I don't see any issues going forward, presuming that the applicant otherwise meets the qualifications for licensure.
That's page 17. I think that probably qualifies for a proposed budget. I would entertain a motion that we accept this proposed budget and the application for capital collection.
I just have one comment, Bart, and it's probably fine, but I just seemed like that the idea behind this was kind of that we wanted to see that someone sort of lots of operating money, just to kind of get up and running, knowing the nature of this business, that it takes a while to review, that they sort of had that cushion, if you will. Is that ringing bells with you? Is that sort of our thinking on asking for this, to make sure that people weren't just trying to sort of open up on a shoestring?
Yeah, I think you're right, to show some sort of balance sheet that they would have enough cash to keep their company alive and operating. I noticed on their application for bond, between 1 and 4 employees, so they're going to be a relatively small company. They're going to be doing collections in other states besides Tennessee. But do they have a financial statement that shows their cash at,
Yes, sir. Page 10 and 11. Apologize if it's difficult to read.
It looks like they just have $1,000 in cash, is that right?
I think that's $10,000.
No.
What's 1,000?
Well, 1,000 in cash, 10,000 in receivables.
And then also
45.
back on page 17, that their explanation states that they believe the $2,000 contingent income represents a low end figure, because I mean, and this is just speculation, but we're probably looking at something like the fee, whatever it is, to enter into the agreement, and then whatever the recovery percentage agreement is on an ongoing basis. It is obviously, and as I mentioned before, basic all the way around and smaller than the board is used to seeing. But again, if their whole universe of liabilities and equity is somewhere in the $15,000 range, and of that, 1,000 cash, 10,000 receivable, so 11 out of 15,000, you're looking at about 2/3 to the positive side of the ledger. Small, and in the case of the receivables, dependent on those actually coming in the door, but not out of the realm of acceptability either. So but that's obviously up to the board, because the Collection Service Act does require that an applicant be financially responsible, and if the board makes its determination that based on the financials submitted that this entity is not possessed of sufficient assets to be financially responsible and constitutes an unacceptable risk to the public, then the board can always deny it on that basis. But if, on the other hand, the board thinks, hey, they're small, but we should give them a shot, I think they'd probably meet the minimum, emphasis on the word minimum, requirements for licensure. So it could go either way.
Motion's been made.
Well, that'd be my only concern. I mean, just looking at that, I mean, like I said, I don't even know how you hire anybody or you send out any letters. I mean, we know it. You've got to spend some money in this business first before you're going to get anything in. And it just doesn't appear that they have.
Well, Ms. Trinkler, it's, and again, speculation on my part, possessed of no information that this is so, but given Mr. Howard pointing out that it's a 1 to 4 employee operation, maybe the investment is sweat equity and it's a one person, or, 1 or 2 closely held family person kind of thing, that they're not really counting on taking a bunch of salaries right now or anything like that. And their hope is to get it going with the basics, and then to make enough money to grow and be paid later. I mean, that's not that uncommon in other areas of business for folks to start a small business, understanding that there are going to be some lean years in the beginning before they hopefully really start to turn it over and get some cash in the door.
And they do have their bond, and with the idea of how small they are, I can't see them getting in a whole lot of trouble before we had another renewal date.
Well,
Yeah,
that's,
I don't want to try to block anybody from trying to get started and understand starting small. I just wanted to bring that up, because it just normally when we're seeing these type of things, there has been enough cash there to kind of operate several months, without the anticipation of generating a lot of income. It just appeared a little to me than what I had recalled seeing. So that's all.
Okay. Motion's been made. Is there a second?
I'll second.
Motion made and seconded. We'll have a roll call vote, Ms. Williams.
Just so we're clear, the motion was to approve the application.
Yes, ma'am.
Bart Howard,
Aye.
Elizabeth Trinkler,
Aye.
Elizabeth Dixon,
Motion carries. Tab 7.
Thank you, Mr. Chairman. This is regarding an entity by the name of Palisades Acquisition, and then in Roman numeral 16. This entity was previously before the board on at its January meeting, and it had applied for a collection service license, and the board had expressed some reservations about what appeared to be a rather large capital deficit and potential cash flow issues based thereon. And the first person that I was able to speak with provided somewhat of an explanation, but frankly at that time wasn't all that satisfactory. So beyond that, I was able to speak with Cornerstone Support Inc., who is the licensing entity, or the entity that assists Palisades with licensure, and they were able to put me in touch with the chief financial officer of the company, who provided, frankly, the explanation I was looking for the first time. And so if you'll look on pages 2 and, well, maybe the first 2 pages
Page two and page 3.
of tab 7, there's a letter from Mr. Robert Michael, Chief Financial Officer, and it goes into further explanation about the cash flow situation. And the piece of missing info that I really didn't have before was that a fair amount of the paper debt obligation of Palisades Acquisition number 16 LLC was to its parent company, which is ASTA Funding. They are publicly traded, and they have, frankly, plenty of money. And so basically, as Mr. Michael explained, there's one sizable debt that they have, which is through, at the end of the day, they owe to the Bank of Montreal, and based in part on the board's concerns about their financial wherewithal, they were able to get a little restructuring done on that loan so that they would be able to meet their payment obligations and not have any cash flow issues. And so with that additional explanation, it looks like they're making more than enough money to pay off the obligations and then have cash left over. And so their remaining indebtedness on that one big loan that they have, as Mr. Michael pointed out, should be paid off in less than a year, which would put us about this time next year, give or take. And then beyond that, the only monies that they would owe would be whatever their obligations are to the parent company, of which they're a wholly owned, albeit indirect subsidiary. So, whatever contractual arrangements they have in terms of, okay, we're the parent, and since you're doing business under us, you've got to render unto Caesar this amount of money. And so, but other than that, once this Bank of Montreal loan is paid off, and it looks like it's on track for that, there don't appear to be nearly the financial issues that there appeared to be when the board first looked at this issue in January. And looks like the Palisades folks have done well and undertaken additional efforts to improve their financial situation and to go even further towards having both the appearance and substance of financial responsibility. So based on those additional efforts and the additional information submitted by Mr. Michael, the CFO for Palisades, I would recommend that the board approve Palisades' application for licensing.
I just have one question. On page 11, they've crossed out debt collection and put debt buyer. Is Palisades 16 going to be a debt buyer and just applying for collection license out of the abundance of caution, or are they indeed going to do debt collection work? ASTA Funding is a huge, I'm familiar with that, and I'm sure Elizabeth is too, a huge company, and I'm sure they're publicly traded and they have no problem making the debt obligations. But if they're going to be a debt buyer, then it makes our decision much easier.
It actually appears that they are a debt buyer, and going back to Mr. Michael's letter, let's see. One moment, Mr. Chairman, while I review the letter. Okay. Looking in the second paragraph says Palisades was created in 2007 as a bankruptcy remote as a company to acquire a portfolio of consumer receivables. So basically, it appears that they're crossing out and putting in the term debt buyer is accurate. And so, and they also state on their application, further down the, well, let's see.
Yeah, they state.
The very next page after where they crossed out and put debt buyer, page 5 of the application and page 12 on the iPad says, do not have any clients. So,
I would entertain a motion that we approve the licensee of Palisades 16.
I'll make that motion.
Motion's been made. Is there a second?
Second.
And seconded. All in favor? Aye. Oh, sorry for the vote.
That's okay. Bart Howard,
Aye.
Elizabeth Trinkler,
Aye.
Elizabeth Dixon,
Aye.
Mr. Harb, and Mr. Hellman are absent. Motion carries.
What, are we on tab 8 now?
Tab 8, sir.
Okay.
Oops. And tab 8 is related to NACARA. The annual conference is coming up. It is going to be held in Boise, Idaho, September 28th through the 30th. What we're seeking is if anyone
In the past, we've had, I think as many as all the board members go to meetings there. I don't think it's necessarily necessary for everybody to be there. I do think it's necessary for the attorney, Mr. Whitaker, to be there. I would personally like to attend. I don't know if anybody else would also, but if the governor approves 2, then, or more, then I'd like to participate.
Okay, I would support that. I would be unable to on those dates, but I would love to have Mr. Howard go.
Okay, we'll just need a motion for whomever the board wants.
I'll make a motion that Mr. Howard attend with Mr. Whitaker.
Motion's been made that the board recommend Mr. Howard and Mr. Whitaker attend the meeting. Is there a second?
Second.
And seconded. Roll call vote, please, Ms. Whaley.
Bart Howard,
Aye.
Elizabeth Trinkler,
Aye.
Elizabeth Dixon, Mr. Harb, and Mr. Hellman are absent. Motion passes, sir.
Tab 9.
Yes, sir. Tab 9 is administration has asked that we go ahead and review the meeting dates for the upcoming calendar year. What you have in front of you are the dates for January through November of next year. And I just need a motion to approve.
Move to approve?
Motion's been made to approve. Is there a second?
I'll second.
And seconded. Ms. Whaley, would you read the roll call, please?
Yes. Bart Howard,
Aye.
Elizabeth Trinkler,
Aye.
Elizabeth Dixon,
Aye.
Mr. Harb, and Mr. Hellman are absent. Motion carries, sir.
Okay. Tab 10.
Tab 10, what you have in front of you is the legislative update that was sent out to all who have signed up for Notify, which is the electronic communication vehicle that the division uses to communicate with licensees regarding rulemaking hearings, legislative updates, and any other pertinent law rule changes that occur. We can quickly sort of go through what is here, and it's actually the third item that,
Kimberly, excuse me, but
I'm sorry.
I don't see a tab 10 on our,
Look after number 1.
oh, I see.
The-
Excuse me.
Forgive me, I'm so sorry. iTunes numbering system, we have tried many different things to put things completely in the appropriate order, and it does not play well with others.
Thank you for helping us find it.
I'm so sorry. Did you all receive this via email? Has everyone signed up for Notify?
I did receive it, yes.
Okay. encourage all board members. That's the best way to keep informed. The first item, and Mr. Whitaker can jump in anytime. The first one is actually the item that we presented at the last meeting, related to the changes directly affecting the Tennessee Collection Service Board. The second item, Public Chapter 815. This is an employment, a certificate of employability, and this is a division-wide, a statute that affects the entire division, not just collection services, but we do make our licensees aware of it. This is very much a statute that relates to individuals, and given that the Collection Service Board no longer licenses location managers, this doesn't directly apply to us. The third item is Public Chapter 881, and this requires that each board or commission within the Division of Regulatory Boards develop a plan to create an apprenticeship program to be used by the board or commission. Again, we no longer license individuals, and there are several boards within the division that do not. So what we will be doing is working with administration to develop a statement to present back to the legislature, because this does require us to report. Just because we don't have individuals, we just have companies. We're not exempt from reporting, but it will be a very simple statement to let them know the type of business that the board regulates, to simplify to satisfy their curiosity as to how we would implement an apprenticeship program. And basically, we would not be instituting it. And if Mr. Whitaker has anything additionally, this is required that we submit this on or before December 31st. So at your next meeting, we will be presenting to you the statement prepared.
I don't really have anything to add. Ms. Whaley did an excellent job of summary, and on the public chapter 815, it's a very narrow thing that talks about individuals who have previously had felony convictions but have had their rights of citizenship restored. It seems like that will be a very low number of people, and even across the whole division is not going to be just something that you see every day, but it was passed by the legislature. So, for example, with the accountancy board, if someone were to have had some issues previously, then the board could come up with a rule that said, okay, well, notwithstanding the certificate of employability, the board may still deny based on its authority for prior felony convictions, subject to the consideration of these factors. So, as a practical matter, that's how it will play out in programs that actually do have individuals who could fall in this category. But as Ms. Whaley stated, that will not be the case here because you guys don't license individuals. So for public chapters 815 and 881, there will be some nice stock boilerplate language full of legalese that we will send to the appropriate folks on your behalf. And when we have it, you can vote to approve it, and that'll be that. So,
Thank you. Is there a motion required?
no.
Okay.
Not at this time. We will have as Mr. Whitaker put it, the boilerplate language to present to you at the next meeting for approval. I do have one final question, and this is actually an email question that we received this morning, and I felt like we would ask the board. Since they're here, my apologies. Someone has asked if there is an official definition of business including inducing form as used in Rule 0320-2-.021B. What does the state consider to be a business inducing form? And it's in your rule book.
And while you're digging for that, I'll go ahead and speak to it a little bit.
In this
And which one is it again, Kimberly?
It's 0320-2-
And it's under the heading of prohibited practices. And basically, it just says all collection services shall not do this list of things. And item 1B that it says is basically, if you're using what it terms a business-inducing form, which this person who is inquiring has astutely pointed out is not defined by statute, you can't use it with font smaller than 10 point. So, you can't use super small 6 or 8 point font. And so they're asking about business inducing form. I would respectfully suggest to the board that the board take a more broad, expansive interpretation of that and basically say pretty much any document that you're going to use that either goes out to the public or has anything to do with your business, 10 point font or higher, please. That would be my take, and that would be my response to this question if that is in line with the board's thinking. But I'm always welcome to hear other thoughts and feedback.
Oh, I think that's fine. I think we would take that position that there's no reason for any small fine print with contracting with a client to do collection work.
Yeah, any written communication.
Right.
Yeah.
All right.
Okay. Well, then in that case, we'll need a motion to approve and second, and then the roll call, and then I will get a response to the person who has made this inquiry by email today.
Okay, so moved.
And seconded, all in favor? Roll call, please.
Bart Howard,
Aye.
Elizabeth Trinkler,
Aye.
Elizabeth Dixon,
Aye.
Mr. Hard and Mr. Hellman are absent. Motion carries, sir.
Thank you, ma'am. Is there any new business? Any other business?
That is all that I have, sir.
Okay. I move we adjourn.
Second.
Thanks, Elizabeth.
All in favor, say aye.
Aye.
Oh, well,
Everybody said aye.
Everybody, aye.
Again, I apologize.
That's
guys.
okay.
But hope everybody